So picture this. You live in a neighborhood, and for 32 years, the same guy has been in charge. And he's not an elected neighbor. No, he's the original developer. Today, we're going to unpack the wild story of one homeowner who decided to take on this 3-decade-long reign. And believe me, it sparked one heck of a legal battle over power, control, and the rights of an entire community.
Okay, let's just start with this quote because, wow, that's a powerful statement, right? It comes directly from the homeowner, Michael J. Morris. These were his opening words at the legal hearing. So right off the bat, he's framing this not as some simple disagreement, but as, in his words, one of the more egregious abuses of power he's ever seen.
So at the heart of this whole thing, you basically got two main players. On one side, you've got Michael Morris. He's a resident, he's already the president of a couple of smaller associations in the neighborhood, and he's the one who finally said enough is enough and filed a complaint. And on the other side, F. Christopher Ansley. He's the original developer, and get this, he's been the president of the Master HOA since 1992. So yeah, this is a classic showdown, a resident versus the guy who literally founded the community.
All right, so where is this all going down? We're talking about a place in Tucson, Arizona called StarPass. And let me tell you, this is not your average little neighborhood HOA. This is a master association. It governs a huge, sprawling community, which makes the question of who controls its board, well, it makes it a really, really big deal.
Now, you're probably wondering, how does one person get to hold on to so much power for so long? Well, it all boils down to this one key term, declarant. That's the official title for the developer, the person who sets up the HOA in the first place. And being the declarant gives you all these special rights, like being able to appoint the board of directors, to make sure the community gets built the way you planned it. But here's the kicker. Those powers, they aren't supposed to last forever. And that's the real question at the center of this case. When exactly should they have ended?
And just to give you an idea of what's at stake here, I mean, look at this. We're not talking about a few houses on a single street. StarPass has something like 600 custom homes, a big condo complex, an apartment complex, and a 576-room JW Marriott resort. All of these are part of over 20 smaller associations that all have to pay fees up to the Master HOA, the one Mr. Ansley controls. We're talking about a multi-million-dollar operation here. Okay, so what was the homeowner's actual case? What did he complain about? Well, Mr. Morris didn't just send a vaguely angry letter. No, he filed a formal complaint that ended up in front of an administrative law judge, and it was laser-focused on 3 very specific things. This was a direct legal shot right at the source of the developer's power.
So let's break these allegations down. They're actually pretty simple. First, Mr. Morris argued that for years, the developer was the only one appointing the board. Second, because of that, homeowners never got a vote, no say in who represented them. And third, the HOA was straight up breaking the law by not even holding the annual meetings it was supposed to. I mean, it was a total lockdown on homeowner involvement.
All right. But of course, there are 2 sides to every story. Let's look at the developer's defense. What's so interesting is that Mr. Ansley didn't really deny the facts. He basically said, yeah, that's what I did. But he argued that everything he did was completely justified, that it was all allowed by the community's own rules and its unique history. His defense is actually a pretty fascinating peek into how a long-term developer thinks. So his defense really starts with the history of the place. He testified that, hey, he wasn't just some random guy who showed up. He's the one who bought the whole 1,000-acre property out of bankruptcy way back in 1992. So in his mind, he rescued this place from total failure and built it into what it is today. And to him, a project that complex needed his steady hand on the wheel the whole time. Okay, but what about the missing meetings? That seems like a pretty big deal. Well, Mr. Ansley testified that he did try to hold meetings years ago, but he kept running into a problem called a quorum. That's just a fancy word for getting enough homeowners to show up to make the meeting official. He said nobody ever came. So eventually, he just stopped sending out the notices. He claimed the rules said homeowners could just request a meeting in writing if they really wanted one. All right, and this brings us to the most complicated but also the most important part of this whole fight. It all boils down to a messy dispute over deadlines, special voting rights, and this one critical question. Had the developer's special powers actually expired years ago without anyone realizing it?
So how did he keep control for so long? Well, it was all thanks to this thing called Type B membership. It's basically a special class of membership just for the developer. It gave Mr. Ansley 3 votes for every single lot he owned or even just planned to build on. Meanwhile, a regular homeowner, that's a Type A member, only got 1 vote. You can see how the math works out, right? It's a weighted system that pretty much guaranteed he'd always have the majority.
Okay, you have to pay close attention to this timeline because this is where the entire case really hinges. So, the document said his right to just appoint the board was good for 20 years, ending in November 2012. But, and this is the big one, his super powerful Type B voting rights were supposed to expire on December 31st, 2010. The problem? The amendment he filed to extend those rights didn't get officially recorded until May of 2011, a full 5 months after they were supposed to be gone.
And that leads us to the million-dollar question for the judge. Can you legally renew a power that has already expired? I mean, can you bring something back to life after it's already, on paper, ceased to exist? Mr. Morris, the homeowner, his argument was simple. Absolutely not.
So, after hearing from everybody, the judge finally made a decision. But you know, it wasn't the simple, clean victory that either side was hoping for. The ruling was actually a split decision, and it came with a twist that I don't think anyone saw coming.
So here's how it all shook out. On the issue of not holding annual meetings, the judge said, yep, that's a violation. The developer broke the law. So that's a clear win for the homeowner. But on the two much bigger issues, the ones about appointing the board without a vote, the judge ruled they were not proven. Wait, what? How is that even possible?
Well, the reason the homeowner lost on those two huge points had nothing to do with the developer's timeline argument. The judge didn't buy that. Nope. It all came down to a ridiculously simple but absolutely critical little detail in the legal process.
And here it is. This one line from the judge's final decision changed everything. The homeowner, Mr. Morris, argued that the developer violated the association's bylaws. Makes sense, right? But here's the thing. He never actually submitted a copy of the bylaws into evidence for the court. And since the bylaws weren't officially in the court record, the judge basically said her hands were tied. She couldn't legally rule that he had violated a document she didn't have.
So what's the big lesson here? I mean, this is a huge takeaway for any homeowner out there. In any legal fight, the burden of proof is on you, the person filing the complaint. You can have the best argument in the world, but if you forget to submit one key piece of paper, you can lose the whole thing on a technicality. Just like that.
So after this 32-year reign, a huge legal battle, what was the final outcome? The big penalty? The developer was ordered to pay the homeowner $500. Just enough to cover his filing fee. That was it. It's really just a symbolic amount, right? It kind of shows that this whole fight was never really about the money to begin with.
And that kind of leaves us with a really big question to think about. Does a case like this show that the system works, that a single homeowner can stand up and force their HOA to follow the law? Or does the fact that he lost the biggest parts of his case on a simple paperwork mistake just go to show how incredibly difficult and unforgiving it can be to challenge someone who's been in power for decades? What do you think?